Good morning, Bruno.
Hey Nick, how are you?
I'm good and you?
Good, good.
Good. So we're back for another episode of PLA. Two questions this morning, and we'll start with yours. So, Bruno, we've had a question from a client who basically said that they bought a property in the circumstances. And in terms of that property, there was an existing gardener that was residing on that particular property. Now, the seller of the property requested the purchaser to take on the gardener, but the purchaser informed them that they weren't interested and they would require the gardener to vacate in the circumstances. And now the property transfer is imminent or has gone through. And unfortunately, what's happened is the gardener who was located on the property is still there in the circumstances. And so obviously now our purchaser has taken possession of this property or ownership of this property. They need to continue with their life, which, including travel or whatever the case is. And unfortunately, now they're sitting in a situation where they've got a person that they don't know, who is now occupying their property and utilizing the property, which obviously places a safety risk for them, in that they don't know who this person is per se. So, can you give us a little bit of information about what to do in the circumstances and maybe where the liabilities lie?
So having an unwanted occupier in your property, obviously, as we've spoken about time and time again, would always require an eviction order, especially if the person is occupying the property. And by definition, occupying is basically with the intention of making it their residence. So it's gone from simple trespassing to the point where a person is actually residing on the property. Now, under these type of circumstances, the first question that we need to ask ourselves is which legislation applies, because South Africa has two pieces of legislation that govern evictions and occupation of the property. The first being PI, the second one being ESTA. Again, we've referred to this quite a few times in our videos. Now, ESTA applies in general, but particular to areas not surrounded by townships. So it's more around rural land, farm areas, that sort of thing. So more commonly, you find that PI is the applicable legislation. Now, both pieces of legislation basically govern the rights given to tenants when they're supposed to be moving out the property, and obviously it governs how landlords need to go about doing this. So that's the first thing that you need to ask yourself is which piece of legislation applies. Now, with a garden, one would normally assume that it's a normal residential house in a township. So I would probably err on the side of caution and say that it would be done under PI, right? So that's the first thing. So can a person simply lock the gardener out and say, don't come back? I don't need you anymore. I don't want you to stay here. No, that would be unlawful. It would be illegal in terms of the act. So number one, it's already a criminal offense. You're not allowed to do it. But in addition to that, if you unlawfully dispossess someone without any legal basis or a court order, that actually gives that person also the right to reclaim possession. It's not a reclaim a right that they have as such. It's not that they're entitled to stay on the property, but the court simply wants the status quo to be returned. That is, everything goes back to the way it was before you took the law into your own hands. So lockouts, changing of gate codes, removal of doors, all those type of acts are a no-no. So you cannot do this. And as a landlord, as a property owner, I do understand sometimes the frustration. You might not know this person on the property. Now you're staying there as all your things are there. So there is definitely a security risk. I do understand that. But if we now start looking at the different steps that can be taken, obviously, aside from the fact that you can secure your house better, the other question you need to ask yourself is, what claim would you have in these type of circumstances? What remedies would you have? Now, obviously, from a security perspective, there's little that can be done short of placing a security guard on the property or placing some sort of caretaker on the property. Well, I take this one step further and say, well, if the seller, in terms of the contract, was obligated to give you the land vacant on the date of registration, and he failed to do so, there is an argument to be made that costs, reasonable costs associated with the fact that the property is not vacant, especially eviction costs, maybe the gray area on security costs, because are they totally necessary or not? That is a matter of opinion. But hypothetically, one could look to the seller to cover any costs that have now been incurred due to the fact that transfer of the property was passed without them fulfilling the obligations of leaving the property vacant. Also keep in mind that there is a value of occupation. So one could also, in theory, argue that if this person is there on the property by virtue of the landlord, in that instance, the value of the occupation should also be covered by the landlord as damages. And again, whether that'll work or not is a different story. You obviously have remedies against the actual gardener. I just don't see those going very far insofar as claiming money from the gardener is concerned, but definitely the eviction claim. On a last note, the other question that I have to ask is the gardener reliant on the salary? Because there's a very big difference between please don't evict someone without a court order versus paying someone a salary who does not actually work for you. Now, in our law, there are circumstances where if you sell assets as part of a going concern, that the employees follow those assets, but those are business transactions typically. And in an instance like this, where the person simply sold the asset, this person does not work for you. And since they do not work for you, you do not have to pay them a salary. So if there's any confusion there on retaining the gardener on the property being tantamount to retaining the gardener's job on the property, so two very different things. And one would have to look at the circumstances of each because different laws and rules would apply to either.
Perfect. Thank you for that, Bruno.